What's the difference between a U.S. patent and a U.S. patent application? Hello and welcome. This is U.S. Patent Attorney Eric Kelly. In this video, I'll go over the main difference between a live issued U.S. patent versus a U.S. patent application. And I'll also go over, when you are looking at various U.S. patent documents, how you can quickly, easily, and confidently tell if you're looking at an issued U.S. patent versus looking at a published U.S. patent application. And this video is current as of at least April 2023. Okay, let's get into this one. Okay, so the main difference that I would like to get across in this particular video with respect to the difference between a U.S. patent and a U.S. patent application is this. It's not possible to infringe a U.S. patent application. One can only infringe a valid and live U.S. patent. A live and valid U.S. patent provides its owner various protections within the U.S. marketplace, whereas just a mere U.S. patent application does not provide these same type of protections in the U.S. marketplace. So if all you have is a U.S. patent application, then you do not have protections in the U.S. marketplace. For example, as long as the given U.S. patent is live, so during its term, that live U.S. patent provides the following U.S. marketplace protections to the owner of that given live U.S. patent. So whoever, without authority of the patent owner, makes, uses, offers to sell, and/or sells any patented invention within the United States or imports into the United States any patented invention during the term of that given U.S. patent, then that conduct infringes that U.S. patent. So that's essentially the gist of the main United States patent infringement statute law, which is found at Title 35 of the United States Code, Section 271. So we'll take a quick look at that statute right now. Okay, so what you're seeing here is just a screenshot image of United States, or Title 35 of the United States Code, Section 271, which is the main statute that discusses U.S. patent infringement. And subsection A here is essentially what I just read. For example, whoever without authority makes, uses, offers to sell, or sells any patented invention within the United States or imports into the United States any patent invention during the term of the patent, therefore infringes the patent. So a live U.S. patent provides these protections in the U.S. marketplace for as long as that U.S. patent is live. Whereas in contrast, the patent application does not provide any of these protections. So this statute here that you're looking at doesn't set forth any protections at all for a patent application. This only applies to patents. So the only protections that a patent application provides its owner is that a patent application can prevent someone else from obtaining a patent on whatever might have been disclosed within that particular patent application. That's the only protection that a patent application provides. So when someone's seeking the protections of a patent, it's important that they get their patent application prepared and filed properly, and then ideally they also want that patent application, that pending patent application that's been filed, to be examined as quickly as possible so they can then hopefully get that issued U.S. patent. And so they can, at that point, then have those various protections in the U.S. marketplace for as long as their U.S. patent is live. So some people often get confused on this particular point, and they think that a published U.S. patent application has patent rights under a particular law, which is often sometimes called the Provisional Rights Law, which is found at Title 35 of the United States Code, Section 154, subsection D. However, that's not exactly how that statute or that law works. So the provisional rights under Title 35 of the United States Code, Section 154, Section D, only kick in after a U.S. patent has issued with claims that are substantially similar to the claims that were published when that particular patent application was published by the U.S. Patent Office. So again, these provisional rights, they only kick in after the U.S. patent has actually issued. And then what happens if you meet these requirements is that you can potentially get royalty, or basically a type of damages, that dates back to before when the patent was issued up to the point back in time to when the patent application was published, but only if the claims that are in the actual issued patent are substantially similar to the claims that are in the published patent application. And that particular requirement is actually pretty unusual. It doesn't happen very much. Typically, the claims that you see in a issued U.S. patent are going to be different from the claims that you see in a published U.S. patent application because of the examination process to get around prior art and things of that nature. The claims are generally going to get tweaked and amended such that the claims that you actually end up with in an issued U.S. patent are usually a bit different than the claims in the published U.S. patent application. So these provisional rights under Title 35 of the United States Code, Section 154, Part D, this particular law section is actually rarely invoked because of that requirement. Additionally, note that that particular section of law that's kind of titled provisional rights, don't confuse that with the concept of a provisional patent application. They're entirely separate and they don't have any kind of overlap at all. So in sum, an issued U.S. patent, a live issued U.S. patent, provides its owner those various protections in the U.S. marketplace for as long as that U.S. patent is live, whereas a U.S. patent application provides absolutely no protections in the U.S. marketplace. It's not possible to infringe a patent application. One can only infringe a valid U.S. and issued patent. However, the patent application can provide some protection in the sense that it can prevent others from obtaining a patent on whatever was disclosed in that patent application. Okay, so let's now talk about how you can tell the difference between a U.S. patent versus a U.S. patent application. So to do that, I'll use an example. So I'm going to come over here to a patent search engine. This one's called freepatentsonline.com. I'm going to go into the search area, get out of any ads, and I'm going to do a quick search here. I'm just going to use a random kind of patent application number that I already found to illustrate how you can tell the difference between what you're looking at here. Okay, so I've entered this particular patent application number, and then I'm going to scroll down to the bottom here, and I want to bring up U.S. patents and U.S. patent applications that are based on that particular patent application number. So I'll go ahead and do that, and we should see two search results pop up, one for the patent and one for the patent application. So one way, or probably the quickest way that you can tell, is by looking at the difference in formats of these two numbers you're seeing here. So a patent application, a published patent application, is going to have a patent application number, and that's what this is. And it's always of the form, so it's in the form of a year, 2022 in this example, followed by 7 digits typically. Okay, so that when you see a number of that kind of format, a year followed by 7 digits, that kind of number is a patent application publication number and refers to a published patent application. But we'll look into this a little bit further so you can see some other additional differences here. So we'll look at the U.S. utility patent first here. And then typically what I think you want to do is look at the actual PDF version, because that's how the actual U.S. patent was issued. And so this is what replicates how it actually looks in real life. So I'll go ahead and download this, but you can see it right here. And we'll talk a little bit about this U.S. utility patent, how you can tell it is a U.S. utility patent. Okay, so I've opened this PDF file of this U.S. utility patent, and this is the cover page, the first page. And how you can tell it's a U.S. patent is that it says right here, patent number. So if this was not a patent, if it's just a patent application, it would not say patent number right here. And then you can see the form of the number. Additionally, you can see the date of the patent. And again, if this is a patent application, it would not say date of a patent. Now, lastly, you can also see there's what's called a kind code, basically a letter and then a number. This one's B2, and we'll talk about that in a minute here. But the kind codes can also just tell you that this is a U.S. utility patent or a U.S. patent and not a patent application. So next, we'll look at the published U.S. patent application version of this U.S. utility patent. So I'll click back, and we'll go into the published U.S. utility patent application. And then again, I'm going to scroll down here and go into the actual PDF version of this. And then I'm going to bring it up, the PDF file here. Okay, so I've opened the PDF file of this published U.S. patent application. And so real quickly, it says right here, patent application publication. So that's an indication that this is a published patent application and not a patent by itself. And again, you can see a publication number, not a patent number. And we discussed the format. It's always going to be a year, typically followed by a 7-digit number. And then again, it says publication date, doesn't say patent date. So all these are indications that this is a published patent application and not just a patent. And again, you notice the kind code here is A1, whereas on the U.S. utility patent, the kind code we saw there was B2. So I'll show you the kind codes, and that can also help you distinguish between if you're looking at a patent, a U.S. patent, versus looking at a U.S. patent application. Okay, so here's a document I pulled up from the United States Patent and Trademark Office that discusses their kind codes, which again, there's going to be a letter and a number that's at the end of a patent number or at the end of a published patent application number. So typically for anything that starts with an A is going to be a patent application, and anything that starts with a B is going to be a patent. So that's another way you can tell whether or not what you're looking at is a U.S. patent versus a U.S. patent application. Okay, to recap, we've looked at how you can tell the difference between a U.S. patent and a U.S. patent application. And the importance of being able to distinguish between the two is because it's not possible to infringe a patent application. One can only infringe a valid patent. That is, between the two, between a U.S. patent and a U.S. patent application, it's only the live issued U.S. patent that provides its owner protections within the U.S. marketplace, whereas a mere U.S. patent application provides absolutely no protections within the U.S. marketplace. The only protection you get from a U.S. patent application is that the patent application can prevent others from obtaining a patent on whatever was disclosed in that particular patent application. So that's at least one main reason to understand the difference between what you're looking at as a patent application or an issued U.S. patent. Okay, this has been U.S. Patent Attorney Eric Kelly, and I do work with clients from all over the world and all over the United States. And as I've noted in this particular video, I am a U.S. patent attorney. However, I'm also a trademark attorney and a copyright attorney. Patents protect novel and non-obvious inventions, so basically new products. Trademarks are a different intellectual property tool, and they are there to protect branding. And copyrights are yet another intellectual property tool, and copyrights typically protect creative work, things like photographs, videos, music, literary works, things of that nature. And then lastly, you can see some contact information for me if you wanted to reach out to me regarding intellectual property matters. Please like this video and subscribe to my channel to help me reach others about intellectual property matters. And here are some of my suggested videos on U.S. patent law matters. Thank you.